Well, it's Friday, so we have Phil Harding, our legal expert, on, and he's been getting a lot of questions about court systems, and there have been a lot of changes since 2019 started, right?
Yeah, since
All right.
2019 fired up, there's a big change, and I thought I would go over because I've gotten some calls. People want to know about small claims court. They want to know if they've gotten sued, what to do. I want to go over the different levels of our court systems and talk about how to move between each level, like on appeals. And let's start off with the beginning. Let's talk about the vernaculars, the words that people use. And so to start off with, there is plaintiff, and a plaintiff is an individual that brings the lawsuit. And then the person that defends is known as a defendant. If it's a divorce action, then there's the petitioner. That's the person who files for the divorce. And then there's a respondent. Now let's look at an appeal. Let's say the plaintiff went to trial, didn't like the outcome, and so they filed an appeal. The plaintiff would become the appellant. Or if the defendant wanted the appeal, the defendant could become the appellant. So the appellant and appellee, that's difficult. Don't worry about that.
Don't worry about it?
Yep. Just know if you're getting sued, you definitely need to talk to an attorney, but you definitely have to file with the court within the time frame. But let's talk about the different levels of courts. And we're going to start with the lowest level and look at this graphic. First of all, it's small claims court. Small claims court is awesome, and let me tell you what's awesome about it. First of all, attorneys are not allowed there. It's made for individuals to quickly resolve their differences. But here's the one limitation. If you can sue for any amount. You can sue for $1 billion, but the most that the court could award you is $7,500. Now, because this is made for the people, this court has nights and weekend times. No discovery is allowed. And let me tell you what discovery is. Discovery is like a deposition, and a deposition is someone taking your statement before you go to trial, or interrogatories. Those are questions that are sent by the other side. And the great thing about it is there's a magistrate there. So at the end of this trial, he's going to tell you, he or she is going to tell you exactly who's right, who's wrong.
Okay. All right. So what do we want to talk about on the next level up?
Yeah, so up from the small claims is what's known as county court, and this is where things really changed. Back up until January of this year, the jurisdictional limit was $15,000. Our legislators said, you know what, we need to increase that because county court helps cases get through more quickly as well. So now it's $35,000. Attorneys are allowed here, and I want you to know this. So if you're in small claims court and the other side brings an attorney, then it's bumped up to county court. But don't worry about that because the judge will almost act as you're an attorney. He'll make sure that you're not getting beat up because you chose small claims court. Getting back to county court, let's talk. You can have a trial to a judge or a jury. The defendant has to answer, and then there's a court date set. And the judges, they can either immediately rule or they can give a written order. And also, court dates are a number of months out. After that, let's talk about now district court. District court is the highest trial court level. And on district court, it's unlimited jurisdiction, which means you can sue for a penny, you can sue for $1 gazillion.
A gazillion?
That's a lot.
That's a lot.
It's a legal term, trust me on that one. Trials are usually scheduled at least a year out, and you do this pre-trial discovery. And look, you don't have to have an attorney. It sure helps when you're in district court. And motions are usually filed. So those are the three different levels here in the state about depending upon how much is in controversy.
Okay, what about appeals? I think we have enough time to talk about that.
Yeah, let's talk about appeals and what happens. You just go up one level. So let's start at the bottom. Small claims court. If you don't like the decision, then you would go up to a county court judge to look at it. Same thing, county court, you go up to district court. District court, don't like it, you go up to the Court of Appeals. There's always something that's a special way to go to the Supreme Court, but it rarely happens. We're not going to talk about that. Now let's talk about from the Court of Appeals, you would go up to the Supreme Court, but here's one thing for you to know. You get only one appeal by right. So if you're in small claims and you don't like the answer, you go up to the county court. If the judge gives you an answer you don't like, you cannot go up to district court unless you file a writ of cert. And that's where you ask permission of court. So remember, you get one appeal by right. Any other appeals, you have to file this special writ and ask permission. Rarely gets granted.
All right. Thanks, Phil. Thanks for coming on. And if
You're
you have a
welcome.
question for our legal expert, go to kdvr.com, click on Colorado's Best. You're going to see Phil Harding's photo right there on the right. Here it is. There it is. Just click there, send in your questions, and he will answer each question personally and confidentially. And to reach Harding and Associates directly, call 303-762-9500. You can also get a free consultation anytime, and you can find him online at hlaw.org. Well, coming up.